this. Earlier, the inspector threatened to spoil his career. Completely a false case, sir.
There in the trial, sir. Prove it in the trial. Where a witness here?
No witness is mentioned in FIR, charge sheet.
What is he doing here now? Charge is already framed.
Yeah, the thing is they are all vague. Even if you...
It may be vague. There.
No, it is mentioned
Idea.
only assault, push. There is nothing. And it is improving day by day.
Maybe. Yes.
There are 164 statements.
In 2 years,
Then,
they failed to
Approximately
submit...
page 40, my lord. Page 40.
What's the offense?
504,
354 is it?
323, 354.
Ingredients of 354 are completely missing.
We'll see, sir.
Intention is mentioned even in the charge sheet.
Page 4, my lord, charge. 40.
In Panchnama also nothing is mentioned.
Adella evidence.
There is no witness mentioned in the FIR and there is no MLC also.
It is an MLC.
Where is
Late MLC is there. Even the case is filed late. There is no emergency treatment.
where is the
Charge sheet at page 4, start from page 43. Well, on the 17, my lord, is at page 53. 164 statements are there.
Moreover, Your Honor, if the case is so serious, why they haven't arrested it till 4 months?
27 months. Last 127.
What's the relationship between you and the informant?
Tenant and landlord only.
You are the landlord.
No, I was the tenant. And moreover, my son has nothing to do into this. Earlier, the inspector threatened to spoil his career and later on he booked a false case. I have spoken to the DCP also. He said a false case can be filed. I said, why a real case cannot
You
be
don't
filed?
tell whatever you have spoken to someone else inside the court.
In the recent in-court hearing, she has become unconscious. Before that, in FIR, that is missing in
It's all right. Yes.
charge sheet also it
58
is
is the
missing.
own certificate.
30?
58 is the own certificate.
58 own certificate.
59 and 60 are the 164 statements.
Certificate also issued by another doctor, not the one who
164
treated.
statement.
Page 59, my lord, after own certificate.
Where is the admission card? Where is the treatment, injury treatment? Only injury certificate was submitted.
Kudil,
Certificate, page 58.
Baptist Hospital.
Yes.
Same idail. Idu page 50.
The treatment is also of heart disease only. There is no injury treatment. And they went to the hospital late at 12 o'clock. The incident they are telling 10:30. Then when she went unconscious, why she is not immediately admitted into the hospital? The certificate is clearly mentioning minor injury. Completely a documentary alibi.
You prove that in the trials.
Kindly issue an interim stay.
No interim.
Completely a false case, sir.
There in the trial, sir. Prove it in the trial.
No witness is mentioned in FIR, charge sheet, not even in
Eyewitness
the
CW5,
Panchnama.
CW6 are eyewitness. 5 and 6 are eyewitnesses.
CW?
5 and 6 are eyewitnesses. CW1 is the complaint, CW4 is the victim, another.
Is it mentioned in the FIR? No witness is mentioned in the FIR. The case is updating in last 2-3 years. For so many times it came to evidence, but even the complainant never
All
appeared.
right. We'll pass orders. The petitioner who appears in person is before the court calling in question proceedings in CC 9024 of 2023 registered for offences punishable under section 323, 354, 504 read with 34 of the IPC. The petitioners are accused 1 and 2. You are representing your son also, is it? How can a party in person represent another person?
He will join, sir. After 28, he will join me.
ಅಲ್ಲಿವರೆಗೂ ವೇಟ್ ಮಾಡ್ಬೇಕಾ?
No, he is studying MBA finally.
Wherever, yes. ಇದು ಬಿಟ್ರೆ ಏನ್ ಬೇಕಾದ್ರೆ ಮಾಡ್ತೀರಾ?
No, not in this city, sir.
No problems. The petitioners are accused 1 and 2 are before this court so and so. The petitioners were tenants in the premises owned by the first respondent, the complainant. Dispute between the two arose and the petitioners have approached the concerned civil court in OS 5893 of 2022 and an order of injunction is granted by the concerned court restraining the respondent from interfering with the possession, i.e. the rented premises belonging to the respondent complainant. The issue does not relate to the said proceeding. On 1/5/2022, what is the date of the incident? On 31/12/2022 at about 10:30 p.m. the incident agide yavattu?
1/5/2022. Between 1/5/2022 to
Before-
31.
Will you please keep quiet?
31/12/2022. Complaint.
ಬೆಳಗ್ಗೆ ಸುಮಾರು 10:30 ನಮ್ಮ ತಾಯಿ. Yes. For an incident that happens on 31/12/2022 at about in the morning hours, a complaint comes to be registered for offence which becomes a crime in crime number 232 of 2022 for offences punishable as aforequoted. The police conduct investigation and file a charge sheet against the petitioners. The after filing of the charge sheet, the concerned court has framed charges and the trial is on. It is at that stage the petitioner is before the court calling in question the party in person is before the court calling in question the aforesaid proceedings. The petitioner appearing in person would submit that there are no allegations, there are no witnesses, the incident itself has not happened, it is all frivolous, there is no wound certificate for the offence alleged under section 324 or 354 as the case would be. He would seek quashment of the proceedings. The learned additional SPP on the other hand would refute the submission, taking this court through the documents appended to the petition which prima facie demonstrate, which according to the learned additional SPP demonstrates that the mother and the daughter, the complainant, have all been abused and also assaulted. The learned counsel seeks, learned additional SPP submits that it is for the petitioners to come out clean in a full-blown trial. I have given my source. The aforenarrated relationship between the petitioners and the respondent being landlord and being tenant and the landlord is a matter of record. The dispute between the two subsisting before the concerned court is also a matter of record. The issue now is with regard to what happened on 31/12/2022. An incident that happens on 31/12/2022 leads to registration of the complaint by the second respondent. The gist of the complaint, as could be gathered from column 10 of the FIR, is as follows, page 17. The police conduct investigation. The investigation leads to filing of the final report, i.e. the charge sheet. The summary of the charge sheet as obtaining in column number 17 reads as follows. While the drawing up the charge sheet, the petitioners, the investigating officer has examined the complainant and other eyewitnesses to the incident and have all been shown as Mazar witness or victim witness or eyewitnesses in the charge sheet. The submission of the petitioner that there are no witnesses to the incident even marked in the charge sheet is contrary to the record. The 164 statement is recorded. A statement under 164 of the victim is recorded before the learned magistrate on 17/2/2023, which reads as follows. The statement, page 51 to 52. If the summary of the charge sheet, the complaint and the 164 statement are read in tandem, it would not become a case that would entail interference at the hands of this court in these proceedings. It is for the petitioners to come out clean in a full-blown trial, which is now in progress. Petitions lacking in merit stands rejected.
Your Honor, my lawyer is compromised in the lower court. That is why we have approached the higher court.
Yes, sir. Next.
15